This Honorable Court of Criminal Appeals is now in session.
We are continuing with the second day of the February docket of the Court of Criminal Appeals, Western Section. Panel today, Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis. I'm Kelly Thomas from Maryville. Each side will have 20 minutes. If the appellant wishes to reserve some time for rebuttal, please say so when you begin your argument. Would you call the case, please?
Elizabeth Harrison versus State of Tennessee.
On behalf of the appellant.
To the court, my name is Charles Kelly Sr. of the Dyer County Bar, and I represent the unsuccessful petitioner Elizabeth Harrison from no relief from the trial court on post-conviction matter. And again, Your Honors.
Hold on just a second, Mr. Kelly. Can you all hear him very well and understand him?
No. There is a strong echo, and I can't, his voice is muffled.
Nick, have you got a thought on it?
Right. As stated, Your Honors, this is an appeal from the denial of post-conviction relief. Dyer County Circuit Court. My client was indicted for stealing a pickup truck. First, I'd like to talk about from behind a restaurant in Newbern, which is in Dyer County. Her father had previously talked about wanting to get his 1993 white GMC pickup truck back from a gentleman that he loaned it to.
Hold on just a second. Wait, just.
Her father, Jeff Harrison, who testified in this case, that he wanted his 1993 white GMC pickup truck back from a gentleman he had loaned it to. She got a call telling her where the truck was in Newbern, Tennessee, in Dyer County. Went to the area behind the Coops pool room, found the white GMC 1993 pickup truck with the keys in it, got in it, drove it to her father's property on Browning Street in Dyersburg, Tennessee, where she was arrested and charged with theft of a vehicle. Wrong truck. It turns out that Mike Glozier, who was at the pool room, had a 1993 white GMC truck with the keys in it. Thinking that was her father's truck, she got in it, drove it to her father's property. Subsequently, she was indicted for it, and Mr. Riley, Skipper Riley, Noel Riley, was appointed to represent her. She talked to Mr. Riley. He said he visited with her in the jail. She served. Excuse me, I'm getting ahead of myself. He made a determination that the mental evaluation on her was stated that she needed some emotional or mental help. That she, one of the elements of the ineffective allegations are that he didn't investigate the case as Strickland versus Washington versus Strickland, Strickland versus Washington says. It would have determined not only that the mental evaluation stated that she had some problems, but she had been hospitalized some 17 or 18 times in a mental or emotional facility since she had been 15 years old. She said from having been raped. Mr. Riley said that he found her to be somewhat very unusual, that you didn't know what you're going to get from her, that she wouldn't stay on the subject matter, and that he thought maybe that her reasoning power had been destroyed if she had been using meth in the past and was unable to reason. And my point is that in the post-conviction proceedings, Mr. Riley admitted that he never advised her concerning what to do in this case. There was obviously no intent to steal Mr. Glozer's automobile, thinking it was her father's vehicle, and rightfully so, with two 1993 white GMC trucks. Sounds like my cousin Vinny. But anyway, that is what happened. She drove the truck straight to her father's property where she was arrested. He didn't even know it wasn't his truck for a few minutes, even after driving it. Mr. Riley said that the victim, Mr. Glozer, was very upset about it, wanted her prosecuted. And in fact, he would have made an excellent defense witness because he was not upset about it at all. He testified in post-conviction, and he would have made a good witness to be called by the defendant or used on cross-examination when he said that I can certainly understand how this mix-up happened because the trucks are very similar, make, color, etc. Mr. Riley said that she never asked him what to do. He never counseled her as to what to do, even though he admitted knowing all of these problems that she'd had in the past. Mr. Riley could have taken pictures of both her father's truck and Mr. Glozer's truck to maybe show to the prosecutor, look, this accident could happen. He didn't get any of her medical records from some 17 or 18 admissions prior. And
were the medical records introduced to the PC hearing?
They were testified about her being there. I did obtain them. They were 2 feet high, and I didn't really see any need. They were over and over and over again admissions of use of alcohol, drugs, emotional problems, etc. They were commented on, yes, sir. But that's not my main point. My main point is that he did not counsel her, advise her of what to do or what the actual elements of theft were, intent being required, of course, for there to be theft. And of course, sometimes, or maybe most of the time, pleading your criminal defendant guilty in some form or fashion is probably the best representation that you can give some of them, but not in this case. To allow her or counsel her to enter this plea of guilty, not an Alfred plea, but testifying that she stole the truck, just wasn't the thing to do, in my humble opinion, Your Honor. And as the leading, I guess, authority in the Strickland versus Washington case, we didn't get a just result from this case because of the counsel's ineffective or no investigation, no consultation with the client, not advising the client that the finder of fact, be it the judge or the jury, would certainly listen to the intent, and it probably would result in a directed verdict because of the lack of intent when you have all the facts thrown in together about the trucks and the mistake in identity of the trucks. Or the trier of the case could have possibly found her guilty of a lesser included offense of joyriding or attempt to commit theft. But in all probability, Your Honor, on that charge, it would have probably been a directed verdict or a verdict of not guilty, because the intent certainly is required, as Your Honors know, and there was none, based on the facts in this case. And the other matter, which I'm not presenting to Your Honors as strong as the facts in this case, is that another indictment was for burglary of an automobile that was parked in New Bern, and the defendant petitioner testified that The dispatcher told her she could get something to eat out of the vehicle and some cigarettes. And this was picked up. She didn't find any, by the way. She didn't take anything. She didn't steal anything from the truck. But she was indicted and also pled to burglary of an automobile. At the same time, she pled to the theft of the automobile, receiving 18 months consecutive sentences on each count. Before she was bonded out by her father, she served 5.5 months in the Dyer County Jail on these charges. And when I asked Mr. Riley for his file on this matter, he had lost it.
What did he say about why he either advised her to plead guilty or went through this guilty plea with her? What was his justification?
He said he didn't advise her to plead guilty. He always leaves that up. He left that up totally to her. And I asked him, did he counsel her on the law and on what to do in the case and what the requirements were? And he said he did not, that he just left it up to her on the transcript from the 11/4/2019 hearing.
What did he say to her about presenting this proof that it was a case of just mistake?
He told her the case was set for trial the next week. And he said, I just need to know what you want to do. Do you want to go to trial or you want to plead guilty? And then she says that he told her that if you don't plead guilty, you're going to get 3 years in the penitentiary. This was also verified by her father, who talked to Mr. Riley independently. And it was also said that she would receive the necessary psychological and mental and emotional help in the jail if she took the plea. Mr. Riley denied, of course, that. Said he didn't say anything about any help or any penitentiary. But he did say, I asked him point blank, did you not offer your opinion to her at all? No, I didn't. I got the opinion she was intoxicated, possibly on drugs, and did not recall what went on. And I think that counsel has a duty under Strickland to advise their client whether or not they ask him to or not. I think there's a duty to investigate. And I think there's a duty to counsel and advise. I don't think you have to be asked first. And that's my humble interpretation of Strickland. And in another matter, Your Honor, in this case, this young lady is now in jail on totally unrelated charges. She has 6 or more pending misdemeanor type charges against her. And she is, as Mr. Riley put it, displays very unusual behavior. But regardless of that, there was no intent in this case to steal that truck, which is required. And it should not have been pled. And we would ask the court for relief in this matter based on that.
Thank you.
Thank you.
On behalf of the appellee.
Good morning, Your Honors. May it please the court. Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the post-conviction court's denial of relief because substantial evidence supports each of the post-conviction court's conclusions that the petitioner's trial counsel reasonably investigated her case and reasonably advised her about pleading guilty. Regarding the investigation allegation, Mr. Riley learned the substance of helpful information about what Mr. Glozier could potentially testify about from law enforcement. Specifically, the record reflects that he learned that Mr. Glozier was very upset that the petitioner had taken his truck. Additionally, trial counsel explained that if the cases had proceeded to trial, he would have challenged the petitioner's mens rea during the offenses.
Well, but it sounds like to me from listening to counsel's argument, while that may have been in trial counsel's mind, he never shared that with his client. He never told her, look, if we go to trial, we're going to talk about intent because you didn't mean to do this. You thought it was your dad's truck and had that discussion with her. At least that's his argument. Is that what the record's going to bear out as far as the testimony is concerned?
Well, Your Honor, I would begin by noting that the post-conviction court discredited the petitioner's testimony. And in Mr. Riley's testimony, he stated that when he received discovery from the state, he discussed that with the petitioner. They also discussed the video recording of the petitioner when she broke into the vehicles at the 911 center. However, shortly before trial, the petitioner informed Mr. Riley that she, quote, just wanted to get it over with. And in his testimony, he said that he didn't discourage the petitioner from pleading guilty because he believed that the state would likely impeach the petitioner's testimony at trial with the fact that she did not inform her father that she had allegedly taken his vehicle. However, he also explained that he and the petitioner discussed the fact that at trial, she could argue that she did not have the mens rea. So they did discuss that trial strategy, and that's found in the third volume on page 33. And prior to the guilty plea submission hearing, Mr. Riley testified that he reviewed the plea waiver with the petitioner. He said that he, quote, went into a great deal of discussion with her, specifically about the sentence. And the petitioner assured him that she could complete the sentence. And his observation was that her demeanor during the guilty plea was fine. And afterwards, she never discussed withdrawing her guilty pleas with Mr. Riley. So to answer your question, Judge Dyer, yes, they did discuss this trial strategy that the best strategy would be to argue that she didn't have the mens rea to commit these offenses. Moving to the guilty plea issue, as I've stated, while Mr. Riley left the decision up to the petitioner as he is required to do under the ethics rules, as his testimony stated, he didn't discourage her because he knew it was a more favorable option. And they thoroughly discussed the plea petition, the ramifications of the plea, her sentence, and the plea petition itself reflects that she understood the ramifications of her guilty plea. She testified at the plea submission that Mr. Riley advised her regarding her pending charges, and she agreed that she was satisfied with Mr. Riley's representation. Moreover, the petitioner was familiar with the guilty plea process. She had pled guilty prior. And at the guilty plea petition submission hearing, the trial court found that her guilty plea was knowing and voluntary. All of this evidence supports the post-conviction court's denial of relief on this ground. And unless this court has any further questions, the state asks that this court affirm the post-conviction court's denial of relief in this case. Thank you.
Thank you, Mr. Kelly. Your rebuttal time, if you wish.
Yes, Your Honor. She did call her father when she recovered his truck and told him that she was taking the truck to his property on Browning Street in Dyersburg, Tennessee. And yes, she could have been discredited but the victim's testimony and her father's testimony and a picture of the two almost identical trucks could not have been discredited. And it's my belief and position that he has a duty to counsel her not to plead and say all the right things to enter a guilty plea when in fact you're not guilty of the crime. Thank you.
Thank you.
This honorable court is now in recess until 1 p.m.